Welcome everybody to this research seminar. I know you have interesting discussions, but it's going to be even more interesting here. I'm very happy to have Mark Klamberg here. He's going to talk about, maybe not the most happy subject, genocide, Sweden, and the fight over a concept. And Mark is professor of international law at Stockholm University, and he also got his PhD from Stockholm University with a dissertation entitled Evidence in International Criminal Procedure. And your research covers international law, criminal law, surveillance, privacy, and, not least, regulations of artificial intelligence. And you have also spent some time in Oxford as a postdoc at Christchurch. The only person I know who was a reader, a docent, before having a postdoc. I think that's unique. I've never seen that before. Very welcome. The floor is yours.
Thank you very much. It's a pleasure to be here. It's the first time I'm here at this venue. So I published this book in November last year. It's in Swedish, but I'm in contact with a publisher in the US, so hopefully it will be translated into English. I will first tell two stories about how this book came about. The first story is very mundane and not very exciting. It was the book has received quite a lot of attention because it came at a time when we're discussing genocide a lot, especially in relation to the Gaza conflict. But the book wasn't written originally with that conflict in mind. I was asked 2021 to write this book. The book was supposed to come out in 2023, but then it takes time to publish a book. So it came now. And in a sense it was timely because this issue is discussed. That's the first story. The second story started already in 2014, and I would imagine that several of you have read Philip Sands' East-West Street, but maybe not all. So East-West Street, for those of you who haven't read it, in Sweden it's Vägen till Nürnberg. But East-West Street, it's basically a story about three persons or families. It's about the author's family, Philip Sands. His family comes from or are connected to the city we today call Lviv, but before it had the name Lemberg or Lvov. And it's a special city in the sense that two very famous legal scholars, Philip Sands is also very famous, but two even more famous legal scholars have been at this university. So one of them is Raphael Lemkin, who coined the word genocide. He did that 1944 in the book Axis Rule in Occupied Europe. So he came from that university. And the second one is Herr Slauterpacht, who he was instrumental in getting the crime against humanity into the Nuremberg Charter, and he was also instrumental for the idea of having human rights. For the Declaration of Human Rights. So all three of them are connected to Lviv and the university there. This book, East-West Street, I think was published in English in 2015. Philip Sands, he was in Stockholm 2014, the year before the book was published, but he had the manuscript. So he was talking about this book already in 2014. He came to Stockholm and gave a talk about his forthcoming book. I wasn't there, but my colleague Paul Wrange was there, so he told me about the book. And he told me that it appeared to be a very interesting book and so on, but there was a gap. There was a hole in the book, and Philip Sands, he explained what this gap was. Because Philip Sands, to write this book, he traveled around all around Europe to Vienna, Lviv, Paris, London, and so on to collect material. But there was one place he didn't go, and it was Stockholm. So why was Stockholm important? Because Raphael Lemkin, he was a Polish-Jewish lawyer. And when World War II started, he had to flee Poland for obvious reasons. He wanted to go to the US, but it wasn't possible. So the only place he could find refuge was in Stockholm. So he came to Stockholm in 1940, and he was at Stockholm University at the law department, where I am now. And at that time, he hadn't published the book, obviously. He had attended a series of conferences in Europe where he tried to introduce two new crimes, barbarism and vandalism. So those two words later was fused into genocide, but already in the 1930s he was thinking about that, and I will talk more about Raphael Lemkin. And he had to flee to Stockholm, and what was important, it was in Stockholm he started to collect material for the book, where he later coined the word genocide. So the work on this book started in Stockholm, and and Philip Sands, he hadn't collected any information what happened in Stockholm, so that was a gap in his book. And I started to think, okay, who should fill this gap? I mean, he was in Stockholm, he worked with international criminal law, and here's a personal story. I'm born in Sweden, but my parents came from Poland in 1969. But my father, he's not born in Poland, he's born in the Soviet Union. And I never cared much about my father's history, because we didn't have any relatives in Soviet Union. They all left. They ended up in Sweden, the UK, Canada, and so on. So I never knew much about, I never cared much about that part of our family history. But I knew the name of the town where my father was born. It was called Borislav. I never checked where it was, I never cared about it. But when Paul told me this story about East-West Street and Philip Sands, I kind of Googled, where is Borislav? So it's 50 kilometers from Lviv. So that made me think, okay, who's going to write this story about Lemkin when he was in Stockholm? I have to do it, because I mean, it's an obvious connection. So in 2017, I had worked for 2 years. I published an article about Lemkin in Stockholm. What did Lemkin do in Stockholm? What was very good was that the professors at Stockholm University who had him as a guest, they put all of their correspondence with the National Archives of Sweden. There's a lot of material with the Swedish police, because as a refugee you had to report to the police every 3rd month. So there's quite a lot of material about Lemkin's year in Stockholm. So I wrote an article about that. But when I wrote that article, I found a puzzle, a question that I could not solve. It was who helped Raphael Lemkin to get the material, because he was in Stockholm and he collected material about what was happening with the Jews in occupied Europe. Who gave him the material? So it's a gap. I will come back to that later. And that made me think, why didn't anyone interview Lemkin and ask these questions when he was still alive? And that made me think, who is alive today who have done interesting things, and that we should ask questions today in order not to kind of in 30th time kind of regret that we didn't ask them. So one of the persons I wanted to write about, his name is Lennart Aspegren. Maybe most of you probably don't know who he is, but Lennart Aspegren, he's special. I will tell you later about him. So I had that was kind of an embryo for a book. I mean, the story about Lemkin and Lennart Aspegren. So when they asked me to write this book in 2021, I thought, well, they wanted a book about genocide for the general public here in Sweden. So I thought, well, one way to write this book would be to just translate what is in English, because there's a lot of stuff in English about genocide, but that would be quite boring. So my idea was instead to write something that would be new. So the material I collected about Lemkin and Lennart Aspegren. So the book I decided to write was Sweden's relationship to genocide. So that's the book, Sweden's relationship to genocide. And the book is divided in 3 parts. So the first part is kind of a historical part. The second part is about trials involving genocide. So we've had a couple of trials in Sweden. And the third part is more political. How is genocide used in a kind of political context? So it's 3 parts of the book. And I will now give you some extracts of the book from these different parts. So if we start with Raphael Lemkin, so he was born 1900, at the year when the century, from the 18th to the 19th century. And we know quite a lot about him because he started to write the autobiography. It was never published during his lifetime. It was published around 2010. But there is an autobiography, so we know quite a lot about him and how his ideas developed according to himself. So Raphael Lemkin, he tells the story that when he was a young child, he read about how the Christians were treated in Rome, how they were killed and how they were persecuted, and that made him think about how minorities are treated. And then he gives more stories, and at the time when he was a student, what was very much on his mind was what was happening to the Armenians, the genocide during World War I. And he, in his book, he recounts a conversation he had with his teacher, his professor, about a trial at that time in Berlin, because there was an Armenian who wanted revenge and killed the Turkish minister who was responsible for the genocide. And this Armenian, he was put at trial in Berlin, and Lemkin was asking himself, why is this person put at trial? The persons who should be put at trial should be the leaders of the Ottoman Empire, the ones who committed the genocide. And his professor replied, well, a ruler can do whatever they want. There's no restrictions according to law. So that didn't sit very well with Lemkin. He didn't like that, and he wanted something different. So he worked as a lawyer in Poland, but also on the side he had his ideas, which we today would describe as international criminal law. And in 1935 he tabled this proposal to have two new crimes, vandalism and barbarism. So barbarism was to kind of kill people from a group, to physically destroy people. Vandalism was to destroy culture, for example, books, buildings, monuments, and so on. So he wanted to have both of these as crimes, and this provided the foundation later for genocide. So Lemkin had a very broad idea of genocide. It was not only about killing people, it was also about destroying culture. He wrote his book in 1944. It was published when he was in the US. At that time, he was working for the US government, trying to assist in finding Nazi war criminals, and he was in Nuremberg. He tried to persuade the prosecutors, tried to get genocide into the trial and to get it into the judgment. He failed. There's no mention of genocide in the Nuremberg judgment. So nobody was convicted under the heading of genocide in Nuremberg. That may surprise you, but it's because it was not a legal concept at the time. It was just an idea of Lemkin. So he was very dissatisfied and felt he was a failure, but then he started to kind of a one-man campaign to have a treaty, an international convention on genocide, and he was successful. 1948, the UN adopted the Genocide Convention, and Lemkin was one of the drafters, so he was involved in the process. So we can see in the early proposals of the Genocide Convention, the early drafts, it was not only about physical destruction, it was also the culture and social destruction of people. In the end, the states didn't like this. Sweden was one of the states that didn't like the concept of cultural genocide, so that's something I write about in my book, because we can find it in the records, the public records from the negotiations, but also in the files of the Swedish Ministry of Foreign Affairs, that Sweden didn't want cultural genocide because they understood it could be turned against Sweden how we treated the Sami. So the Swedish representatives, they said that in public, we cannot have this in because it would be turned against Sweden. And you can also find it in the records of the Ministry of Foreign Affairs. So that was left out. Other things that were special during the negotiations, and I've looked especially what was important for Sweden, because genocide, the definition as it is today, as it was adopted in 1948, is that it constitutes of 5 acts. What people normally think about is the first one, killing, but it can also be that you're causing damage, injury to people. It can be that you transfer persons from one group to another. It can be that you prevent births, and it can also be that you create circumstances which would lead to the destruction of a group. So it's these 5 acts. In order for it to be genocide, not all 5 have to be fulfilled. It's enough if it's only one. But what is important is that it's not enough that it's 1, 2, or 3 of these acts. It also has to be committed with the intent to destroy a protected group. And in the Genocide Convention, they list 4 groups. So it has to be one of the 4 groups. It has to be either a group based on ethnicity, race, nation, or religion. So what was the Swedish contribution? Well, in the early drafts of the Genocide Convention, it was only 3 groups: ethnicity, race, and religion. What Sweden added was ethnicity. And why did we do that? Well, in Sweden at the same time, there was a draft law on hate speech. And in this law on hate speech, ethnicity was kind of the key concept. So these, you can see in the records of the Swedish MFA and the Ministry of Justice that these processes were kind of dealt in parallel and seen as related to each other by the Swedish the Swedish government. So Sweden tabled a proposal to have ethnicity as a protected group. It was accepted, and it's very important because most trials, or I would say all trials, almost all trials on genocide today, they're not based on persecution or that you destroy a group based on race, because it's not really a concept that we use today. It's rarely religion, rarely nation, but it's mostly ethnic groups. So it was an important contribution that Sweden made. Now, it was not obvious for Sweden to support this work. Some of you, especially those of you who are from Sweden, are familiar with the so-called Uppsala School, or in English you would say the Scandinavian School of Realism. And so that's a kind of, originally it was originated from a philosopher in Uppsala, and he had students in Uppsala, lawyers, who adopted his kind of ideas. And the kind of key thing was kind of separate kind of moral ethics from the law. It shouldn't be conflated. And in their view, ethics, morale was something metaphysical and something you shouldn't kind of deal with. And this was very kind of practical in Sweden in the 1920s, 30s, and the remaining parts of the 1900s, because the idea, and I would say mostly, the Swedish kind of political idea, was to kind of transform Swedish society into modern society, and this should be done by the parliament, by the politicians, not by the courts, not by the lawyers. So it was practical to have lawyers who kind of thought that the only thing that matters is the law adopted by the parliament, and what we think is morally or ethical, it's kind of put on a secondary tier. That doesn't mean that these people were reactionaries in the sense that they wanted kind of protect anti-progressive, as we would say today, because the perception was that the parliament, the politicians, they're modern. They're going to bring us into the modern modern society. So this is the way to do it. So among these kind of Scandinavian realists, you can find both scholars who were social democrats, but also people who we describe as kind of reactionaries. For example, Olivecrona, who was in Lund. I write a little bit about Olivecrona here. So you could find, this also had consequences for how you look at international law and human rights, because many from this school, they thought this as some kind of humbug. This is something we shouldn't kind of deal with. So there was some skepticism in Sweden initially towards the Nuremberg trials, actually, but also kind of the concept or the idea of human rights. Later Sweden has become a big supporter of this, but there was some resistance. So that's a little bit kind of the historical part. Now I will move over to more the trials, and again I'm going to try to have a Swedish connection here. So nobody was convicted under the heading of genocide in Nuremberg. The first trial, international trial, when somebody was convicted for genocide, it was 1998 in the UN Tribunal for Rwanda. It was a case, the name of the defendant was Akayesu. And Akayesu, he was not a very important person in the grand scheme. He was a mayor in a town, and he was involved in the genocide. And the reason he was the first one to be convicted, he was one of the first they got caught. So it's kind of just a practical explanation. But it became, I mean, it's a historical judgment because it's the first international judgment where somebody was convicted for genocide. And the Swedish connection is the following, that there were 3 judges, and one of the 3 judges was Lennart Aspergen, a Swedish judge. So Lennart Aspergen, some of you might have met him. You have? Yes. So Lennart, he's 94 years old. He lives in Söder here in Stockholm. So he was one of the kind of key motivations why I wanted to write the book, because I thought that, I mean, it's a historic trial and there's some questions, some interesting aspects of that case. So I wanted to kind of ask him these questions and get it into a book, which I did. So some of, and first we may ask, why did Lennart Aspergen become a judge in this trial? So Lennart, he has a very interesting history. His mother was born in Iraq. And her father was a doctor and was educated by Pasteur in Paris. So it was kind of a family with kind of educational resources, if I may say so. Now, after the Ottoman Empire fell, the family ended up in Northern Africa. Lennart Aspergen's mother met a Swedish man, and they married, and they got Lennart in the 1930s. And he was raised in his home speaking French. So when they wanted to have, and then he educated himself to a lawyer, made a very good career in the Swedish court system. He ended up in the Supreme Administrative Court, or Supreme Court for Insurance Issues. We don't have that anymore. It's part of the Supreme Administrative Court now. And he worked at government offices. So he made a very good career. And then when they were going to elect judges, they needed judges who could work both in English and French. And that's why Sweden suggested him, because he was fluent in French, was a judge at the high level. And that's how he got elected. Now, if we're going to talk about this Akayesu case, what was interesting in this case, not only that it was the first case when somebody was convicted for genocide, there was 2 other aspects which were very interesting and quite innovative in a sense. Now, the prosecutor wanted to have an easy case because it was the first trial ever for genocide. What they discovered during the trial, the judges, was that many victims and witnesses, they were not only talking about killings, they were also talking about mass rapes. But the prosecutor hadn't included rapes in the indictment. It was formally outside of the trial, but the witnesses and victims, they were coming back to this issue of mass rapes all over the time. So the judges, they asked the prosecutor, well, shouldn't you amend the indictment and include the rapes and the sexual violence? And the prosecutor did that. So in the end, Akayesu, he was not only convicted for involvement of killing people, but also for the mass rapes. And the mass rapes were considered to be an act of genocide. Because in the Rwandan culture, if somebody was raped and they got a child, they were not excluded from their group, but also the child was excluded from the group. So the mass rapes were part of a strategy to have the women and their children excluded from their own group. So it was part of the destruction of the group. So that was something that the court found. So that was something important, that mass rapes can, under certain circumstances, be an act of genocide. The second innovation or interesting part of this judgment is that so the prosecutor claimed that this was the destruction of a group, the Tutsi, and they were an ethnic group. Now this was a little bit problematic because the Hutu and Tutsi, they have the same language, same history, to a large extent same culture. So it's quite, it's not obvious that it's two different groups. So the question was how to deal with this, how the tribunal dealt with this. So they said that we should not only look at objective factors such as language, religion, and so on. We also have to look at subjective factors. How do these two groups perceive themselves, and how do they perceive each other? That's also part of defining a group, how you perceive yourself and how you perceive each other. And that is something that they ruled, and which has been accepted later by later courts. So it's something quite interesting. In this book, so I write about the case, how Judge Asperger became a judge here. I also write a little bit about there was some corruption at this tribunal, or quite a lot of corruption. So that was part of my interview with Lennart about the corruption, because he was given the task to deal with this corruption because he had experience of Swedish administration, so he was considered to be a suitable person to do it with this. So that's also part of the story, how he was fighting with these corrupt persons at the tribunal. And that's also some new material which hasn't been told before. We've had 4 trials in Sweden concerning genocide. So I described these 4 trials. 3 of them related to the genocide in Rwanda. And there's one part of that story with the Swedish cases which I find very interesting. And I mean, those of you who are from Sweden, you're well familiar with Thomas Bodström. I mean, he was a politician in Sweden, Minister of Justice and so on. And after he left kind of party politics, he went back to become a lawyer, a defense counsel. He was involved in 2 of these cases, the second case and the third case. And he wrote a book about this. It's a very interesting book. And so he faced a really interesting dilemma. In the second trial, I mean the first trial for him, he was counsel for the victims. So he were representing the victims, and he wanted the defendant to be convicted. He was representing the victims. And the defendant was arguing that I've been framed. The Rwandan government has they've given false information to the Swedish prosecution, and they just want to get me convicted because I'm a political opponent of them. So I've been framed. Now Thomas Bodström, he was representing the victims, so he was saying, no, this is real evidence, he should be convicted, that's it. And he got convicted. Now for the third trial, I mean the second one for Bodström, he was not representing the victims, he was representing the defendant. And the defendant in this trial was making the same argument. I've been framed, it's fake evidence. And the interesting part in this trial was that the defendant, who was obviously from Rwanda, a couple of years before he had been involved in another trial in Sweden, because the Rwandan government, it's authoritarian, it's not kind of a democracy in the way we would like to see it. And they are spying on their former citizens in Sweden. And the Swedish Secret Service, they discovered this. And they had been in contact with this person who later became the defendant. So he was a witness used by the Swedish Secret Service to testify that there was espionage. The Rwandan government was conducting espionage against former citizens in Sweden. So he was helping the Swedish Secret Service, and he was afraid that there would be retribution from the Rwandan government. So he asked the Swedish Secret Service, you have to be prepared. They will try to get back at me for this because I've testified against them. And that's essentially what happened, that the Rwandan government presented evidence, gave it to the Swedish prosecution, and so in this trial, in the genocide trial, not the espionage trial, but the genocide trial, you had policemen from the Swedish Secret Service testifying on behalf of the defendant, supporting the story of the defendant. And this was a dilemma for Thomas Bodström, because in one trial he was saying the evidence is real, there's no conspiracy from the Rwandan government, and then in the second trial he had to kind of change and argue the opposite. Yes, there is a conspiracy from the Rwandan government. They've corrupted the Swedish criminal process. So it's an interesting story and a dilemma for a lawyer. How can you argue one thing in one trial and another thing in a second trial? The fourth case, which is very recent, it's a judgment from February 2025, and it was in the appeals court here in Stockholm in November 2025. So it's a very recent judgment. It concerns a woman, her name is known in Swedish media, Lina Ishak. She has been subject to 2 trials in Sweden. The first trial was involvement in recruitment of child soldiers. Her children were recruited as soldiers by IS in Syria. So that was the first trial. I'm not going to talk about that. I'm going to talk about the second trial. So in the second trial, because it's a woman who was from Sweden, a Swedish citizen, she moved to Syria, to Raqqa, and joined IS. And in her home, she had Yazidi women and children as slaves. And they also forced the children to convert from their religion into the IS version of Islam. She wasn't involved in killing anyone, so she was indicted, charged at Stockholm District Court for enslavement and for converting these children from their religion to Islam as a war crime, crime against humanity, and genocide. So war crime and crime against humanity, I mean, it was quite straightforward. If the evidence was there, quite easy to convict her for that. But genocide more tricky, because she wasn't involved in killing anyone. In the end, Stockholm District Court convicted her, because as I told you, genocide is not only about killing, it's also forcing children from one group to another. So, I mean, it's kind of reasonable that she was convicted for genocide also. I mean, the prosecutor could show that it was part of a larger scheme of a genocide against the Yazidi. So it was not that strange. But what was interesting was that the Stockholm District Court, they said that the genocide was not only physical in nature, it also had a cultural and social dimension. So if you remember what I told about Lemkin and his understanding of genocide, barbarism, vandalism, and what he tried to do with the genocide in 1940s, which the states didn't like, Sweden opposed it. They didn't want to have cultural genocide because of the Sami. It was excluded from the Genocide Convention. And then Stockholm District Court in 2025 brings it back. So that was something interesting. That they're talking about genocide in a cultural and social sense. So I wrote the blog post about that, where I wrote it was interesting. I didn't want to be too critical, because I thought it was good that she was convicted for genocide, but it was a little bit strange that they kind of went against what was decided in 1948 Stockholm District Court. It went to Svea Appeals Court, and they were more conservative in the sense, so less talk about social and cultural genocide. But it's an interesting case. So it's I've been asked last week to write for an international journal about this case, because it's an interesting question about this culture and social genocide. Now, the final case I want to talk about, they all have a Swedish connection, as you understand. It's about Nouri. He was, I guess most of you are familiar with this case. There were mass executions in Iran 1988 of political dissidents. It was mainly 2 groups. One group was People's Mujahideen, kind of a group that kind of mixed Islam and socialism. And the other group was kind of leftist, secular activists. So they were executed, we're talking about 5,000 or 6,000 in 1988 within 3 or 4 weeks. So it was something that was covered, it was publicized already at that time, but maybe forgotten now. But it was revived by this trial. So Nouri he was working for the prosecutor in Iran at one of the prisons. And the victims that survived and their relatives, they want justice, obviously. So they've been tracking these people, and somehow they persuaded Nouri to come to Sweden to visit a relative. He had a relative here in Sweden. And this victims group, they contacted the Swedish police. So when he was flying to Sweden, the Swedish police was waiting at Arlanda airport, and they arrested him when he landed. Now, I was involved, I have to make a full disclosure here, I was involved in this case in two respects. Because when the victims groups contacted the Swedish police and they told him, the police, Nouri is coming to Sweden, the Swedish police said, we cannot do anything. Because this was 1988, it's more than 25 years, because in Sweden, a crime is subject to prescription, or in English statute of limitations, after 25 years. So the Swedish police said, this is more than 25 years, we cannot do anything. The victims group, they turned to me, is this true? The police cannot do anything. And then I told them that in 2009, Sweden changed its law. So when it comes to genocide and war crimes, there's no 25-year limit. We did this in 2009. Can somebody guess? Why did we do this in 2009? You have to think, what happened 25 years before 2009? No. Palme. Because 25 years before 2009, that's 1984. So if you want to have the case ongoing in the Palme case, you have to remove this 25-year rule for murder. And then the politicians said, okay, if we're removing the 25-year rule for murder because of the Palme case, let's do it for genocide and war crimes also. So that happened in 2009. It went to legal effect 2010, just to kind of save the Palme case. And that's kind of all lawyers in Sweden know that, or should know. So I told the victims group, I mean, we changed the rules in 2010, so you can still prosecute the mass executions from 1988, and the police accepted that, and they arrested him. So that was the first part where I was involved. And the second part was because it was tricky for the Swedish police and the prosecutors what label to put on this crime, because this sounds like crime against humanity. Crime against humanity is when you attack a civilian population, you kill them, you torture them. So it sounds like a crime against humanity. The problem for the Swedish police and the prosecution was that we did not have crime against humanity as a crime in Swedish law in 1988. So they had to be a little bit creative. So they asked me, Mark, can we prosecute this as a war crime or as genocide? So war crime was possible because People's Mujahideen, those of you who kind of remember, they were fighting against the Iranian regime, and in the 1980s they had to move from Paris to Iraq. So they had some kind of protection under Saddam Hussein, and they were in a camp in Iraq. And at the end of the Iraq-Iran war, they were fighting against their own country. They were fighting on behalf of Iraq against their own country. So I kind of told the prosecutors, or they already had that idea, there was a connection between the Iraq-Iran war and the executions, because the reason why the Ayatollah decided that these executions should happen was because People's Mujahideen was fighting for Iraq. He was very angry because of that. So that's why he issued a fatwa that they should be executed. So it was quite easy to argue it could be a war crime. Now, there was a second group, the left-wing activists. They were not fighting for Iraq. They were not involved in any way in the Iraq-Iran war. So it couldn't be prosecuted as a crime against humanity. It couldn't be prosecuted as a war crime. So what remained was genocide. So if you kill people who belong to a left-wing group, is that genocide? Now, if you remember, there's 4 groups that are protected: nationality, ethnicity, race, and religion. There was a discussion in 1948 to also protect political groups, but the states didn't want that. It was excluded. It was mainly because of the Soviet Union. They didn't want to protect political groups from attacks. so political groups were clearly excluded in 1948. But I tried to build an argument for the prosecution that atheists are protected under the Genocide Convention. Because if you think about religion, that atheism is kind of a view on how society is and how the world is constructed. It's in a sense a faith. It's kind of a non-religion. And under human rights law, you had the freedom of religion, and it has been interpreted not only to protect religious people but also atheists. That's how freedom of religion has been interpreted by human rights courts. So I was trying to build an argument that atheists or people who have converted from Islam or kind of left Islam are also protected. So I write about that in the book. In the end, the prosecution didn't buy that. They didn't prosecute for genocide. They thought, I've spoken to them, that the evidence was not really there. Instead, they prosecuted for murder, because thanks to the Palme investigation, murder was also excluded from this 25-year rule. So they were prosecuted for murder, and he was convicted for murder. So that's the cases I have in the book. Lastly, I have the third part, is the political part. And there's many things here. I kind of write about a little bit the Iraq war. I'm thinking about 2003, humanitarian intervention, responsibility to protect. I'm seeing that my time is coming to an end, so I will not talk about that. Instead, I will talk about the Gaza war, because when I published this book, there was also at the same time a lot of discussion whether a genocide is taking place in Gaza. So I will talk about that. So it was something I didn't really have in the book, in the manuscript initially, but I gradually kind of, while I was writing the book, I was also giving interviews in Swedish media, because I got questions in Swedish media. Is it the genocide in Gaza? And as kind of I'm a scholar who kind of taking part in the public debate, I kind of try to kind of offer my assistance or my view. So what you do as a lawyer, because it's very kind of people easily kind of get caught in either side and have kind of predetermined views on this matter. As a lawyer, what you try to do is that there's a method. I mean, there's a legal method how we kind of do law, and there's sources of law, and a very important source of law is obviously case law. So when I get this question, I kind of go to the case law, because the case law have defined how to understand the different criteria and also how is genocide proven. So I mean, that's how I kind of, when I get questions, how I think about it. I don't give the journalists all of the cases, but that's how I kind of construct my answer, my reply. So I have to give you a little bit of the relevant case law. So one question is, how many people must be killed in order for it to be genocide? And the Genocide Convention, it doesn't have a number. So the Genocide Convention doesn't help us. What the Genocide Convention says, if we read the text, is that genocide is if you have the intent to destroy in whole or in part a protected group. A whole or in part. So this word in part, it means that you don't need necessarily to have the intent to kill the entire group for it to be genocide. So then the question is, what is in part? How many is that? I mean, the treaty, the convention doesn't give us any information. The only thing it has is in part. But this became an issue in the trials relating to the Srebrenica genocide. Now in Srebrenica, groups or militaries belonging to Republika Srpska, a group representing the Serbs in Bosnia who wanted to break away, they were responsible for the genocide in Srebrenica, and they killed 8,000 men and boys, from not only men who were in the army or in the age when you're a soldier, but also very young men and old men. And it was in a specific part of Bosnia. So the prosecution argued that the prosecution tried to persuade the court that there was a genocide in the entirety of Bosnia. Srebrenica was the most obvious example, but the prosecution tried to argue it was a genocide in entire Bosnia. The Tribunal for Yugoslavia and the International Court of Justice, it's two separate courts. You have the Tribunal for Yugoslavia, where you have individuals who are put at trial, and then you have the International Court of Justice, which have its disputes between states. But in both of these courts, you had the Srebrenica massacre or genocide. And what these courts said was that there was no genocide in the entire Bosnia. However, it was a genocide in Serbia. Both of these courts say that. And they are very similar in their reasoning. So what they say is that, okay, they only killed men, they didn't kill women, but if you kill all the men of a group, the group cannot continue to exist. So that was part of the argument. Another part was that they killed people in one region, and that made that group disappear from that region, and it has a substantial impact on the entire group that there's no people from that group in that region. They didn't say that it has to be 8,000, but it's still the case which kind of with the lowest number of victims. So it's some kind of indicator when you can have a genocide. So when I think about if we transpose this into the conflict in Gaza, because one argument is it cannot be a genocide because you have Palestinians living in Israel proper. I'm thinking about, for example, Haifa or other kind of Israeli cities. It cannot be a genocide because they're not killing the Palestinians there. They're not killing the people in the West Bank. There's bad things happening in the West Bank, but they're not kind of killing them as a group. It's only something happening in Gaza. Then my response would be, you don't need to have an intent to kill the entire group. That's not the requirement. If you kill people in one part, it could be enough. Now, you cannot stop there. Another kind of important question is the question about intent. Why is this happening? I mean, if we're talking about the Gaza conflict, why are people in Gaza dying? So how do you prove intent, that you have intent to destroy a group? Now, if you would charge somebody for genocide during the Holocaust, it would be easy because the Nazis, they wrote it down. You have the protocols from Wannsee. It's easy. There's a protocol and they write what they're going to do and then they're doing it. So it's quite easy. Now, what we can see in later genocides, that the genocidaires, they don't write it down. But people are still convicted for genocide. So how can you convict people for genocide if they haven't written it down? So again, you have case law which says that you can use what we lawyers describe as circumstantial evidence, that you have many different pieces of evidence, and a single piece cannot prove something, but taking together, it can prove what the prosecutor is arguing. And in the genocide cases at the Tribunal for Yugoslavia and ICJ, the court have said we can use this kind of a pattern of evidence if they all point to the same conclusion. If the evidence is pointing in different directions, then we cannot prove genocide. So that's how they go about. So we can use a pattern of evidence. There doesn't have to be a written plan, but if the evidence is pointing in the same direction, then that could be enough. So now I was giving interviews, and I have all of this case law in my head. I got this question in October 2023 and November 2023, and I was thinking like this, okay, people are dying, Israeli politicians and representatives, they are saying things that I would normally find in genocide cases. They said quite terrible things. But there was also a kind of another story, which was there was hostages. Hamas was still perceived as some kind of threat against Israel. So there was kind of two stories here. One story was the genocide story, and another story was that Israel did this to combat Hamas, free the hostages. And so in my mind, there was kind of a pattern of evidence, but it was pointing in different directions. So I said, I don't think it's enough to say it's a genocide. Then what happened was that the conflict continued, and there was a change in the administration in the US. And if you remember what happened early 2025, that Trump, he posted this video of kind of the Gaza, how would you say it? Resort. Yeah, and he was saying publicly that the Palestinians should be moved somewhere else, neighboring countries. And Netanyahu, he was I thought Netanyahu was surprised, because that's not the stuff you hear from a US president. So I think Netanyahu, he started to say things he was thinking about before but never said, because he understood it would be inappropriate. He said, yes, this is an excellent idea and we're going to carrying it out. And that's how he described this plan by Trump. And also at the same time, this was the 2nd of March, they made a public statement, Netanyahu, but also other Israeli officials, that no food or humanitarian aid should enter Gaza. And that you had that situation for 11 weeks, and you also have different organizations who were present in Gaza who were saying we're having starvation. People are either starving to death or danger at starving at death. And so in my mind, if you remember, I said there's 5 different acts that can be genocide. It's killing, it's causing damage to a group. But the third criteria, I mentioned that before, is that you create circumstances with the intent of destroying a group. And when you read case law and the kind of legal commentaries, what is causing circumstances? What does that mean? And now I'm reading cases, I'm reading books which are not about Gaza. They're saying that this means, for example, starvation or destroying the homes of people on a massive scale. That's what it means. So that's what is happening. And then the leaders are making statements that there's not going to be, or we're going to move the Palestinians away from here. And the instrument for this, as I saw it, was starvation. So then again, I'm thinking about these alternative stories. So we have one story about genocide, and then we have another story fighting Hamas, protecting Israel. And this story here got a lot more weaker, and the genocide story, in my view, got a lot stronger. So that's, I gave an interview in August where I said, well, the facts have changed. Something has happened in the spring of 2025, and I think you can describe this in terms of genocide. So this caused a lot of attention. It was a little bit challenging. I mean, it's this is very politically controversial. What helped me a bit was that an Israeli organization at the same time said the same thing, and there was other colleagues in Europe. In Sweden, this organization, I think it's EAGS, they made a statement. It caused a lot of debate in Sweden because they had some kind of referendum among their members. I don't know if you remember that, about whether it was genocide or not, so it was criticized. I thought all of that was a little bit strange. What was more important for me was I didn't care about this organization, to be honest, what they said, because I didn't think it was a really serious way of doing it. What I listened to was my fellow scholars, because I know who's knowledgeable and not. So in France, in one of the French newspapers, 180 colleagues published an article in French where they argued in the same way as I did, as I've presented now. And for me, I mean, that was in a sense, I mean, it helped me that I mean, you're not alone when people are saying the same thing at the same time. This wasn't reported in Sweden because we don't read stuff in French, but I think that was important, so that has been described as, I mean, Mark has changed his mind or something like that, but that's not how I see it. When the facts change on the ground, because facts can change as time goes by, you need to adapt your description of what is happening depending on the facts that you observe. So I mean, that's nothing strange in my view. Now, on a final note, I mean, this is the Institute of Future Studies, and maybe I've misunderstood your task, but let's talk about the future. So I mean, many are thinking about what what will happen with international law now when we have a new US administration and so on. And I think international law will survive, but in a different form. I think these global institutions, I'm mostly thinking about the UN, are obviously much weaker now, and it's nothing I welcome, but that's just how it is. But I think international law will still have an important role. We can see that in the national courts we have a lot of cases relating to international crimes, and also other parts of international law are relevant in a domestic context. I'm thinking about, we have a massive discussion now about migration and how we treat refugees, and it's a lot of it is about international law. We still have the European Union, the European Court of Human Rights, important institutions. They have the same in South America, there's a court in Africa. So I think international law will survive, if I may say so, through domestic and regional institutions. They will be weaker at the global level because they need the support of the US, which we don't really have now. Another kind of thing for the future is, again, going back to the Gaza situation. There's an ongoing case between South Africa and Israel. So there will be a judgment, maybe 2027, 2028, I don't know. So, I mean, one could speculate how that will go. I would like you to keep your eyes on a judgment that will come this year. It's between Gambia and Myanmar, because Gambia has filed a complaint against Myanmar for genocide, and that judgment will probably come this summer. And it has many similarities, or some similarities, to the case between South Africa and Israel. It's basically the same judges who are in both of the cases. So I think if you want to kind of know how, or if we want to kind of have a better understanding what will happen with the case between South Africa and Israel, we obviously this case between Gambia and Myanmar will be interesting and important. Now that's my presentation, and we can open up for questions and comments.
Thank you very much, Mark, for that fascinating talk. I'm sure there's going to be many questions. We are entering now the question and answer period. I will remind you about the rules of engagement. So if you're here in the audience and you want to ask a new question, put up your hand. If you want to follow up to somebody, you put up a finger. And for you online, you use the chat box of Zoom, and you can write your name and area of study, because we like to find questions from different areas. And then we will call upon you. And if you have a follow-up question, just write who you're following up to. With that said, I guess we're going to start with someone who was very, very quick. Ori.
Thank you. I was curious about what you said about the Swedish officials back in the day not being willing to include the sort of the destruction of culture in the definition of genocide. And you mentioned that they resisted that because they were worried about sort of their own actions towards the Sami. But does that mean that, as the definition is today, a reasonable case can be made against the Swedish case of genocide against the Sami population, you think?
I'm here as a lawyer, so the field of genocide studies is broader. There's others who are doing genocide studies also, historians, sociologists, cultural anthropology and so on. And they have sometimes a broader understanding of genocide. So they, if you would ask them, they would say under their definition of genocide, yes, it could be genocide. Now I'm kind of this boring lawyer, so I kind of look at the legal definition in the treaty and the case law. So my answer would be no. However, we had this case from Stockholm District Court last year, and I wrote a blog post about it. So I wrote that, well, if they're saying that there's something, a concept such as cultural and social genocide, it kind of might open up the doors for what you're aiming at. Now, the Svea appeals of court, they in a sense kind of closed that door. So I would say no. I'm not saying that there were no atrocities committed, no violations, but I don't think a court would label it as genocide, as the law is.
And I mean, it's very hard to find intention in this case, I guess.
Well, you could argue that the Swedish state had the intention to assimilate the Samis into the Swedish majority people, and in that sense they would disappear or cease to exist. But the counter argument would be it has to be physical. People have to die or disappear, and that's what is lacking.
Could I follow up on that? Because
yes.
One thing, I mean, I'm fascinated by this kind of legal conceptual engineering and how creating new laws, new crimes.
Yeah.
And it just struck me, I mean, intention is always very hard, but then, I mean, if you're not sentenced to murdering somebody, you might be sentenced to manslaughter.
Yes.
Because the intention was unknown, but you still kill somebody. Is there any idea of having something similar like that? People slaughter or genoslaughter or something like that? That is a kind of like genocide, but without the explicit intention.
Yeah, but we already have those crimes.
Ah.
So we have murder, we have war crimes, we have murder as a crime against humanity. So that's also something I write in my book, that we're kind of very focused or fixated at this concept of genocide. And it's only if it's genocide, it's serious. But I would kind of... Now, I'm kind of contributing to that narrative. I understand that because I've written this book, so I'm contributing to that narrative. But we should be careful. Other crimes are serious as well. So if you don't have this intent to destroy a group in the sense of the Genocide Convention, it can still be other crimes, and other crimes are also serious. I mean, crime against humanity is a serious crime. So if you cannot prove that intent, it can still be a crime against humanity.
So no need for this genoslaughter then?
No, not as I see. There's a lot of colleagues, especially in other fields in law, they want to invent new crimes. I'm skeptic towards that. I think the crimes we have are good as it is. I mean, I understand that people want more justice, but the problem is not in the definition of the crimes that we need new crimes. It's more we need to have access to evidence. We need to be able to arrest the persons. I mean, that's the difficulties, that's the challenges, and that's where we need kind of focus. And maybe I'm sounding very negative now, but we don't need new crimes. We don't need new human rights. We have a lot of human rights already. It's more the challenge is rather in terms of implementation, making it happen.
Good. We're going to have our first question from the online audience. Rebecca Stern, I hope. That's Erika, not Rebecca.
Yes. So, hello everyone. Hi, Mark. Thank you very much for that really interesting presentation, and I'm looking forward to reading the book. Sorry, I couldn't be there in person today. So, I'm coming back to the idea of cultural genocide. So, first, a really nerdy legal question. The case in the Stockholm District Court that you referred to. What did they base their arguments on as regards cultural social genocide? Did they draw on an expansive interpretation of the Genocide Convention, or did they sort of make things up as they went, or how did they go about it? That's my first question. Yeah,
it's a very lawyer question, but I've asked the same thing. It's very good. It's very good.
Yeah. So secondly, you mentioned in the beginning of your talk when you talked about the history of the Genocide Convention and the Swedish connection, you spoke about the influence of Scandinavian realism on perhaps the understanding or adoption and acceptance of the concept of genocide. If you could expand a bit on that would be interesting. Whether the idea of, the Scandinavian realists are reluctant to the idea, as you said, the whole idea of human rights, but how did that play into if it did, the acceptance of the concept of genocide? Thank you.
Yeah, thank you for those two questions. So the first question is really interesting because if you read that part of the judgment, the district court doesn't have any references. It doesn't have any references how it could be such a thing as a cultural or social genocide. So then you start to think, as a legal scholar, how does this happen? Did they listen to someone and then they didn't want to write it in the judgment? So what I did, I started to read the preparatory works. The law was amended in 2014. And what I found, that the phrase that the district court used was identical, verbatim, word by word, to what was in the preparatory works. So in the preparatory works, they write the same thing, and they have a reference in the preparatory works to a case from the Tribunal for Yugoslavia. But it's not any case, because there's many cases on genocide in the Tribunal for Yugoslavia. So in the preparatory works, now I have to explain this who are not Swedish lawyers, or even if you're Swedish and not lawyers, you may have, you don't know this, so I will explain. In Swedish law, each national legal system have sources of law, so it may vary. So Sweden and Scandinavia is a little bit special. We have 4 sources of law. That's what we teach our students. It's statutory law. That's what comes from the parliament. We have case law. That's normal for most countries. What makes Sweden is a little bit different. We have legal doctrine. So that's what we, the professors, say. That's you have in other countries. What is really special about Scandinavia is preparatory works. So that's the documents that are prepared by the government before the law is adopted by parliament. And so we Swedish lawyers, we're trained when there's a gap or some kind of something is unclear in the law, we go to the preparatory works to find the answer. So in the preparatory works, so that's the stuff that the government prepared before the law was adopted. They have this phrase, the same that was used in the judgment, and we Swedish lawyers, we're trained to follow that. Now, and we do that somewhat mechanically. We don't question it. But what they did in the preparatory works is that they didn't make a reference to the mainstream judgments from the ICTY. They followed a separate opinion. That's a judge that doesn't belong to the majority of the tribunal, who wants to a reservation. So I have a different view. So what the preparatory works is they chose something that was really outside of the mainstream. They put that in the preparatory works, and then the Stockholm District Court copied that without giving a reference. And that's kind of, if you're a normal Swedish lawyer who's not doing Swedish law, who's not doing international law, that's what you should do. But if you're international law, you start kind of, this is crazy. Because, so that's what they did. And I contacted the prosecutors and the defense counsels, because how did this happen? Could the court just do this on their own, read the preparatory works, and then did they discuss social, cultural genocide during the trial? So the prosecutor said, well, we were reading from the preparatory works during our opening remarks. So that's what happened. I've tried to reconstruct it. The prosecutors, they read from the preparatory works. The court took it into the judgment without the reference. So that's the answer to the first question. And then the second question was Scandinavian realism. Now it's a little bit embarrassing because this is from Uppsala, you're from Uppsala, so maybe I'm describing the school in the wrong way.
Number of Uppsala philosophers here too.
Yes. So I have to apologize if I misrepresent this kind of school in the wrong way. But one of the main kind of names during this time was Wilhelm Lundstedt. He was, also connected to the Social Democrats, and I would say kind of a progressive. But he wrote the book, I think it was 1934, with the name "Why International Law is a Threat Against the People." And you have to understand. So this is a professor in international law writing "Why International Law is a Threat Against the People." And you have to understand the background in the 1930s was that the League of Nations was not working. You had kind of wars in Ethiopia and so on. And what people were seeing, that international law is not doing anything. It's not helping people. So it's in a sense it doesn't exist. And that's why it's called in English, that's why it's called realism, that we have to look at what is happening, not what in the theory, we have to look at what is really happening. So there was a skepticism. When we talk about Nuremberg, there was criticism in Sweden how the Allied Council was established to kind of control occupied Germany. And the Nuremberg Tribunal was founded on the basis of this Allied Council. So that was kind of the initial skepticism from Sweden. They quickly changed their mind, because when news reporting was coming from Nuremberg, you kind of heard they were reading in the newspapers the testimonies, what's happened. Sweden very quickly changed and was very supportive of what was happening. But that was kind of the mood. And if you read specifically about the Genocide Convention, the perception was that we don't really need the Genocide Convention from a Swedish perspective, because we have already criminalized murder and manslaughter and all the other things. So we don't really need genocide, but we're still going to support this because other countries might need it. So that was kind of the rationale in Sweden. It was very interesting also. I have to find now, my memory sometimes fails me, but there was a very interesting person at the Ministry of Justice. Yeah, his name was Gerhard Simson. So Gerhard Simson, he was originally from Germany. He was a German Jew who came to Sweden, I think in the late 1930s. And he started to work for the Swedish Ministry of Justice. And he was the one who wrote parts of the reports inside the Ministry of Justice, which only became available 50 years later. So we can read it now, but it wasn't available at the time. And it's very interesting to read what he writes about it, because you can see how he's struggling against the Scandinavian realists. That's how I understand what he's writing, because he's kind of trying to persuade the readers, the others at the Ministry of Justice, that there's something called natural law, that sometimes morale and principles, they have to take priority over the human law, the law that is adopted by Parliament. So he's kind of, in one of these texts, he's making that argument, but the impression I get that he's very careful, because he knows that this is not very fashionable to argue in this way in Sweden. So it's a very interesting piece to read. So that's how I understand the discussion at the time.
Are you happy with that, Rebecca?
Thank you so much. Yes.
And no Uppsala philosophers seem to be protesting. Did you have a follow-up? Okay.
Yeah.
I'll come there. Then next is Karim.
Thank you. Yeah, this was very interesting. I would like to ask a question about the evidence that emerged in 2025 and how that changed your point of view.
Yeah.
So you said that the facts change in 2025 and that made you change your view. But did the kind of evidence for intent, so that changed, but does that also imply that we have reason to believe that the intent was there before 2025?
Well, some would argue that maybe it kind of inform us what happened even before. One could make that argument, but I'm kind of this is so controversial, so I'm trying to be a little bit cautious here. So I'm kind of restricting myself to spring 2025. But one could definitely make that argument that what you say during spring 2025 could inform us or kind of make us reassess what was said already in 2023 and 2024. One could make that argument.
Yeah, like the Amalek comment.
Yeah.
I mean, there are many interpretations of that, of course.
Yeah.
But if we believe that there is an intent in 2025, since it's like the leadership has not changed substantially, at least, then we could kind of. But so it's like if you would reason in a non-judicial context. I mean, just did did he do it, or was he unfaithful or not? Then we often say like, okay, so we know today that he was unfaithful, so probably he was unfaithful last year, for example. But is this reasoning similar to that in the kind of judicial context?
Yeah, you could make that argument, definitely. Now, it's maybe I kind of gave the impression that I'm very skeptical towards other scholars than legal scholars. I'm not. So when sociologists look at genocide, I've lost the name now, but there's a famous scholar who've kind of described genocide that happens in 10 or 11 different steps. I mean, it starts with dehumanization and so on, and then it kind of gradually gets more serious. So they describe genocide not as an act or an event, but a process. And I think that's fair. I mean, from a kind of sociological or psychological viewpoint, I think it's accurate. I'm not questioning it. The difficulty for us lawyers is that a crime has to occur at a certain place, which is geographically delimited, and within a certain time period. So when you have a trial, the prosecutor has to define a place and a time. And so it makes us a little bit kind of square, the lawyers, in a sense, where we need kind of delimited. So that's what I'm doing. But yeah.
Okay, next is Tommy Ringert online.
Yes, thank you. I was wondering how you look at the genocide discussion in Gaza today. I mean, you talked about things changed 25 on the ground, and things have changed since then. You talk about, intent, talk about the starvation, and also this discussion about starvation. There are proof that the discussion about starvation back then was not true, that they really had a lot of food, but that the food was stopped by Hamas. So this accusation against Israel that they forced the starvation on the Gazans doesn't hold water. So my question is, have you changed your opinion again about the genocide in Gaza? Is it still going on, or what's your position today?
Yeah, I mean, there's at least two questions there, so I'll take them in turn. So the first question is, do I argue that there's still a genocide in Gaza today? So as I said in my previous comment, is that we lawyers, we kind of delimit crimes. It's limited in time and space. So we have to look at the situation now, today. What is happening today? Do we have starvation today? What kind of statements are Israeli leaders doing today? So I would say probably no genocide today. I mean, I could be wrong, but that's how I see it today. I mean, it's a different situation. I think the statements made by Trump and American administration, I'm not saying it's great, but it's different. They're not talking anymore about deporting Palestinians to other places and so on. But that's, I don't see contradiction in my view in that way, because a crime can start at a certain point and stop at a certain point. So there's no kind of nothing strange in itself that you can say that the genocide happened, let's say, between March and June 2025, and then something else happened afterwards. So that's the kind of first question and my first response. Then the second one, I mean, there's proof that Hamas stopped food and so on. I mean, at the end of the day, it's an evidentiary issue. And I mean, there's a trial ongoing in the ICJ. And I mean, I have to be kind of intellectually honest. It could be that at this trial, Israel or someone else presents evidence which kind of contradicts me, and the court accepts that. And then I need to look at that evidence and kind of consider that. And you should always, if you're kind of intellectually honest, be able to reassess. But I'm not doing it yet, and I'm not on the way to doing that. But I mean, you should always be open for that. Now, I know in this discussion there's been references to UN reports. There was UN reports that some claims support that Hamas was taking the food. But if you look at those actual reports, it said that yes, there was plundering and so on, but it doesn't say necessarily that it was Hamas, because as I see it, what was happening in Gaza was that there was chaos and people wanted food. I mean, there was kind of a very difficult situation. So it was different people, could be Hamas, could be other groups. The UN doesn't kind of say that in that report that it was Hamas, it could be other groups. And at the end of the day, what is important is what Israel said, I mean their officials, and what they did. And then Hamas did also things that didn't make the situation worse. But if we're talking about Israel and this charge against them, that's what's important. What did they say and what did they do? And yeah, that's would be my response.
Happy with that? Okay, then
Can I just have?
Sorry.
I have a general question, not really a follow-up, but still, I mean, you do talk about that this is a very sensitive and very political issue. I mean, genocide is from a non-legal point of view a very, very strong word, and And would you say, how do you deal with that as an authority in this field? Would you say that you have been misinterpreted before when the discussion was ongoing, or how do you deal with that?
Well, I mean, during this conflict, there's some people who have said it's a genocide all of the time, and then there's some people who have said there's never been a genocide. What I think is kind of the serious way to approach this is kind of you have to look at different time periods. That's what I'm trying to do. And second thing, I mean, this genocide is it's a very strong word. I mean, it's kind of some would argue kind of most gravest accusation. And so if I may make a reflection on that, and some have said we cannot use that word for other events than the Holocaust during the World War II. Because if we describe the situation as genocide in Gaza, we're kind of equating what is happening in Gaza, what happened to World War II. And I disagree with that, because when they adopted the Genocide Convention in 1948, they could have said, we're not going to have a genocide convention, we're not going to use the word genocide, we're going to have a Holocaust convention, where we outlaw Holocaust. And if there's no death camps, if there's no gas, if there's no Nuremberg laws, there cannot be a Holocaust. They could have done like that in 1948, but they didn't. They separated the two concepts, Holocaust, which is kind of what happened in World War II, and genocide. And genocide is kind of more open in the sense it doesn't have to be death camps, it doesn't have to be gas, it can be other situations. If you read Raphael Lemkin, because he was thinking about Rome, how the Christians were treated by the Romans, he was thinking about the Armenians, he was thinking about culture, so he had a very broad understanding of genocide, which would capture more situations than the Holocaust. So I think one problem in this debate is that when we're conflating genocide and Holocaust, it's not the same thing. And I think it's good that the two words, the two concepts are separated, because otherwise genocide as a word would be useless or not possible to use at all.
Very good. So the next question, lady there.
I just want to say,
Hold on. You need a microphone. Is this a follow-up or a new question?
yeah, follow.
Okay.
Yeah, a comment. I mean, it's just also the Genocide Convention was to prevent Holocaust or prevent something. So, I mean, that's the delicate part, when to step in, right? I mean, it's not something you do after. It's something you want to learn a lesson from the Holocaust to prevent.
Yeah, I think that's a good comment, because there's been a discussion in Sweden and also other countries that because politicians, I mean the representatives of the Swedish government, they've been asked, is this a genocide? And then the Swedish politicians, they've answered that this is an ongoing case at this International Court of Justice, so we cannot respond to that. And I think it's a little bit problematic, that answer. I can understand why they're saying it, but it's a little bit problematic because of the point you're making. Genocide is not only about punishing afterwards. We cannot just wait for the courts. It's also about preventing. However, I still have some understanding for the Swedish politicians who want to kind of be a little bit careful, because it's a kind of a difficult discussion. You don't need to label it as genocide in order to act. We had this discussion that there's other crimes against humanity and war crimes. You don't need to label it as genocide to act, to do something. So I can understand why the Swedish politicians are a little bit careful, but it cannot be used as an excuse for inaction. That's my important point.
John, did you have a follow-up too?
Yeah.
No, I have
A new one. Okay, we will get to you. So let me, the lady there.
Okay, thank you. So I had two questions also on Gaza, specifically because you spoke earlier on Haifa, and Haifa has been part of Israel since 1948. We know that, but since then there has been expansion of Israel regarding occupation and settlements being created and Palestinians being forced out of their home and being forced to go into separate areas. And since we know that moving a population out of their territory and specifically to another area, that can also be considered a genocide, and we're specifically talking what I was thinking of is there's, for instance, this woman called Daniela Weiss, who was also suggested for the Nobel Peace Prize last year by two Israeli very famous scholars, who has overseen settlements through the IDF, who has been mayor twice of illegal settlements, and has gotten very significant support through the government of Israel, and she herself is quite frequently heard calling for a repetition of the Nakba. And phrasing like that, I'm wondering, that's question number one, could that be evidence of, number one, genocide in the sense of removing Palestinians from their homes, and also evidence of dolus specialis, essentially?
Yeah.
And then the second question I had was, because we have acts of genocide, which is killing, sterilization, for instance, etc., but then there's also acts punishable, so incitement to genocide, complicity in genocide, etc. And then you spoke on Trump and his West Bank Riviera, I believe he called it.
The Gaza Riviera, I think.
Gaza Riviera in his famous AI video. Could there ever be a case, if you were to say genocide did occur at that time, for instance, for incitement to genocide on part of Trump? Because we have, for instance, Nicaragua v. Germany in front of the ICJ, where Germany is accused of complicity. So would there ever be a case to be made theoretically? I know practically that's not a very real,
no, I think if we start at the end with Nicaragua versus Germany, I think that case is halted or discontinued because Germany, it was because they were providing arms to Israel, but Germany actually changed their policy on that and stopped some exports. So I think the case was somehow discontinued. I don't know the finer details. But coming back to your initial question, so when we talk about forced removal and so on, I mean, it's clearly a crime. It's clearly a crime. Then the question is, what label should you put it on it? It's quite easy to label it as a war crime or the crime against humanity. That's easy. So for genocide, it has to be the physical destruction, so that makes me a little bit cautious to describe what's happening on the West Bank. It's clearly a crime. No hesitation in that, but I hesitate to describe it in genocide because it's not kind of the same level or as destruction or killing. I mean, there is killing, yes. But it was something different in Gaza as I see it. Now, you talked about incitement. So before spring 2025, I was asked what will happen in the case between South Africa and Israel. And so I kind of, it's a bit speculation, but this is what I said at that time, was that, well, maybe they will not find that Israel has committed genocide, but Genocide Convention, and I was saying the same thing as you're saying now, it's not only about committing genocide, it's also incitement, and you definitely had incitement in Israel for genocide at that time. I'm thinking about Ben Gvir and Smotrich and so on. You definitely had that. So my prognosis at that time was that the ICJ will not find that it was genocide. I've changed my view now. But they could find it was incitement. So I think what will happen at the ICJ, either they will go all the way and say it was genocide, or they could be more cautious and a little bit in the middle and say it's incitement. So I think that's quite probable that it will happen, that the ICJ will say it's incitement and Israel didn't suppress it because they have an obligation to suppress it. So I think that's very likely. Then we come to Trump. Yes, I think, I mean, the way you phrased it theoretically, yes, it could be considered incitement, but there will not be a case. Yeah.
We have a little shorter time, so very quick follow-up. It has to be very quick.
Just because you mentioned Ben Gvir, there is an ongoing debate in the Israeli Knesset to have essentially due process be removed and to start the essentially killing under Israeli law of Palestinians currently held in detention camps or, prisons. Yeah. You said you don't consider that it is an ongoing genocide. Would you consider that essentially to be something that would contribute to genocide in that instance?
Yeah, I mean, it depends on under what pretext, but yeah, it could be something considered, yes. Yeah.
On that note, join me and thank Mark for this fascinating and learning talk.
If I may do some self-promotion here, I have the book with me, so if anyone wants to buy it, you can pay me by Swish.
And you still get 10% of the profit, huh?
Yeah, to you.
Yeah, okay. Very good. Next week we're going to go skiing, but after that, 4th of March, we have Nicola Mulken talk about exploitation and time, future generations, social roles, and structural injustice. And then we have 11th of March, Jesper Roine, who is a professor of economics at Stockholm School of Economics. We don't know the title yet, but it will be good. See you then. Thanks.